Contracts are the backbone of business and personal agreements, but what happens when you need to get out of one? Understanding how to legally exit a contract is crucial knowledge that can save you from potential legal and financial headaches. A contract is a legally binding agreement between two or more parties. Once signed, it's generally enforceable by law. However, there are circumstances where a contract can be voided or terminated without legal repercussions. Let's explore some acceptable reasons to void a contract. Impossibility of performance is one such reason. If it becomes impossible to fulfill the terms of the contract due to unforeseen circumstances, either party may be able to nullify it. For instance, if you hire an event planner who unfortunately passes away before completing the job, the contract would be terminated. Another valid reason is fraud, mistakes, or misrepresentation. If one party acted unethically, both parties made the same mistake, or there was dishonesty involved, the contract could be voided. An example would be purchasing an item believed to be authentic, only to discover later that it's not. Breach of contract is perhaps the most common reason for termination. This occurs when one party fails to honor the agreement. However, only material breaches, which violate the central part of the contract, are typically grounds for litigation. Many contracts, especially those involving consumer goods or services, include a cooling-off period. This allows a party to cancel the contract without penalty within a specified time frame. For instance, the Federal Trade Commission's 3-day rule permits consumers to cancel certain contracts made at home or outside a regular business location within 3 days. Force majeure clauses are another important consideration. These allow for contract termination when unforeseen events make performance impossible or impractical. Natural disasters, government regulations, pandemics, or labor strikes are common examples of force majeure events. Sometimes, the simplest way to exit a contract is through mutual agreement. This is known as mutual rescission, where both parties formally agree to end their contractual obligations. Negotiating a termination might involve partial performance, substituting a new agreement, or one party waiving their rights under the contract. Many contracts also include specific termination clauses or exit provisions. These outline conditions under which the agreement can be ended. Common types include termination for convenience, which allows either party to end the contract at any time with prior notice, and termination for cause, which permits ending the contract if the other party fails to meet agreed obligations. While these methods provide potential avenues for exiting a contract, it's crucial to remember that breaking a contract without legal justification can result in serious consequences. These may include financial penalties, lawsuits, or damage to your professional reputation. Given the complexities of contract law, it's always advisable to seek legal counsel when attempting to exit a contract. An experienced attorney can review your agreement, identify legal exit options, negotiate with the other party, and help minimize any associated risks. Understanding how to get out of a contract legally and effectively is valuable knowledge in both personal and professional contexts. By familiarizing yourself with these concepts, you'll be better equipped to navigate contractual relationships and protect your interests when circumstances change.